and welcome back. You're watching The Money Show on ET Now. We are in the midst of a health crisis, as we have, of course, all been grappling with the day-to-day difficulties of keeping ourselves safe, our families safe. However, if we have to get really pragmatic and practical about it, one often does wonder that, God forbid, if something happens to you, what happens to my kids, my family, especially if they are dependent on me. And that's the reason why estate planning or will planning is extremely important. Now, many of you may be wondering that estate planning is something that does seem to be a task for the HNIs and for the people who have a plentiful of assets with their name. But I guess it's important for everybody to ensure that they bequeath in an orderly fashion whatever assets they've accumulated over to their heirs, be it their spouse, their parents, their children, just so that later their family does not have to sort of go through the entire process and worse, sometimes litigation, as we all know too well. So let's bring on board Mr. Hemant Rustagi to talk about the entire process of wealth creation, why it assumes so much important, and of course get some of your questions and queries answered as well. Mr. Rustagi, many thanks for joining us today on ET Now. So yes, let's start off with that first. Why does creating a will or an estate plan assume so much importance for everybody? I'm not just talking about of course those people who have plenty of assets to their name, but even for the common man, why is it that he or she needs to create a will?
Well, Mubina, creating a will is actually a part of the estate planning or succession planning, and I totally agree with you when you say that it's not only for HNI. I think it is basically useful for everyone, irrespective of how much wealth you have, to create a will. And I think the reason why it's important to create a will, or rather it's why it is always advisable to have a will in place at all times. I mean, more so in the kind of challenging times we are facing right now, where there is a constant threat to our health and life. And considering that creating a will is a very, very important aspect of your financial planning, it has to be done at a time when you're not under any pressure or under any panic, and you're of sound health and of mind. So it's very, very important to do it at the right time. And if you ask me, the right time is now if somebody has not done it. But there is a process is involved when you talk about creating a will or the estate planning. So there are 3 or 4 steps which are involved, which I think everyone should follow. Of course, like we already said, why it is important. So what is the process that you need to follow for that? One is you need to decide as to who the beneficiaries are going to be. That's the first step. The second is that if there are more than one beneficiary, who gets how much? And the third is make an inventory of all the assets which you own. And the fourth step in the estate planning process is to create a will. So it's important to have a will, and it's important to follow a process so that every important aspect of this process is taken care of.
Okay. Well, yeah, I think what you mentioned about being in the right frame of mind is extremely important, not too, bombarded with nerves, with emotions. And yeah, I think that point which you mentioned about being in the right frame of mind is extremely important. Now, coming back to that point of why will planning is important for everybody, when we say that we are creating a will to leave for our kids, what assets are we talking about? I mean, when you say asset, frankly, to the layman's mind, the first thing that comes to my mind at least is, okay, the house that I have. But what assets are we talking about? What should be listed down in a will?
Well, Mubina, when we talk about assets, basically we're talking about all kind of assets, which include the physical as well as financial assets. In fact, I would say when you want to list out the assets in your will, you need to be very, very specific. For example, if you have an account, the account number should be mentioned. If you have insurance policies, those details should be managed. It will be clearly mentioned over there. If you have investments, each and every detail of those investments should be clearly spelled out. And if you have more than one property, again, like I mentioned, you need to be very clear, specific. All details have to be mentioned about when this properties were purchased. And the second is what is the complete address of these properties. So it's important to cover both financial assets as well as the physical assets. And also, I think it's very important for everyone to remember that if there are more than one beneficiary, how you want to allocate, the allocation should be in terms of percentage, not by writing the value of the property, because any asset, whether it's property, whether it's a financial asset, the value of that will constantly keep on changing. So mention in terms of percentage if there are more than one beneficiary, but make sure that each and every asset you own, whether it's physical or financial, is a part of the will.
All right. Okay, so there you have it. It's important not to do it in a percentage-wise kind of a form. Also, sometimes when you think about the other, I guess the notion in all of our minds is, creating a will is a very complex process, involves a lot of legal paper, green paper, and visits to the lawyer's office, or, in today's times, of course, video calls with the lawyer's office. What is the process then of creating a will? I mean, do I need the entire legal battalion with me when I'm drawing up a will?
Well, the best thing about creating a will is that it's a very simple process. It can be actually written on a piece of paper. Obviously, there is generally a format. The date has to be there and the certain thing which have to be covered. So it can be done on your own. There is not necessary that you need the help of a lawyer. But the fact is that we all know that the wills can be contested in the court later on. So the last thing that you want is that to miss out something which is very important, and then that is contested by somebody later on. So I think it's, even though you don't require it, it's always advisable, to ensure that all the legal frameworks are taken care of by taking help of a lawyer. In fact, there are a number of online portals which help you create your will, and they take into consideration all the legal aspects. So like I mentioned, it's not necessary that you have to take a help of a lawyer, but it's always advisable. In fact, another thing that you can do is actually, if you can make one of the lawyers sign as a witness in your will. So what clearly happens is that the lawyer will vet the will that you have made, and when he signs that, really a proof that that this will is complete in all respects.
Now I want to talk to you about the recent Supreme Court ruling in light of that. Now, the reason why I ask you this is the Hindu Succession Act is still very much the basis on which a lot of family businesses are run, what we call as the Hindu undivided family, right? There's no clear structure as such, and all the members of the family participate in sort of taking the business forward. I just want to understand the entire estate planning process in light of an HUF, and if the Supreme Court ruling is something that would perhaps change the way or should individuals keep that in mind, or do you think that maybe now an HUF is too passe, there are too many changes in rules, rather keep a trust with equal rights given, or equal rights given to basically all the heirs of the individual?
Well, I think let's talk about the Supreme Court ruling, which you mentioned just now. The reason why I feel that there are two aspects to be taken note of. One is that Supreme Court ruling is basically about the equal right for the daughter in case of inherited property. As we were discussing earlier, if it is a self-acquired property, and while writing a will, I don't think the Supreme Court ruling will have any impact on that. The second is whether it should be a trust or whether it should be a will, or whether it should be a HUF. I personally feel that I agree with you that I think HUF, I won't say has lost its relevance, but I think there are better options available here. So my view is that it should be a combination of, again, depending on the structure which is there in the family, a combination of will as well as the trust. And the reason for that is that when you talk about a will, it comes into effect after the death of the creator of the will. Okay, and you know that it can be contested in the court of law. But if you talk about a trust, there are many advantages of actually having a trust in place. One is that I think it minimizes the taxation when there is a transfer of asset. The second is it separates individual from the assets. Now, for example, if there are any financial crisis, okay, and the person goes insolvent, the lender cannot touch the assets. The second thing is that when you talk about a will, it's public, it's governed by the court. Whereas if you talk about a trust, it's private and is governed by the family. So I feel that the trust has certain advantages over other forms, but a combination of will and a trust can be very good. See, the reason for that is during your lifetime, you will still keep control of all the assets which you own, but you separate those assets, which means that you're protecting the interest of your family member during your lifetime. And of course, after the death, whatever is mentioned in the will, that comes into effect. So I think a combination of will and a trust will be the ideal for anyone.
Okay, well, very interesting, and I hope all of our viewers, take note of all the points that Mr. Rustagi has mentioned. I think tax is something as well, the tax implications that you've touched upon, a great point over there. All right, well, I want to move on and understand that does a will have to be registered with some sort of government authority? I mean, if I just simply write it down on a piece of paper and bequeath assets to all of my individual heirs, I mean, what is the legal enforceability of such a will?
I think it's a great question. Like I mentioned earlier, it can be written on a piece of paper, and there is no legal requirement that it has to be registered with any government authority. But as I mentioned earlier, there are certain grounds on which the will can be contested in the court of law. Now, what happens is when you register a will with the government authority, it minimizes the number of reasons for which the will can be contested. Now, for example, if the will is registered, it cannot be contested on certain grounds like the person was of unsound mind, or the person was forced to sign this will, or the signature are forged, because there is a proof that the person went and got this registered. So I think it's not necessary in terms of law, but I think it's again advisable to register it. Like I said, you minimize the chances of somebody contesting this will in the court of law.
Okay, so there you have it. It's all about, I mean, like Mr. Rustagi as well mentioned, as such, you can sort of do this simply over a piece of, a piece of paper as well. But yeah, it's important that you do it. That's extremely important. And, why don't you do one thing, Mr. Rustagi? Tell us what will happen if you don't create a will. Just advise our viewers about the drawbacks of not having a properly made will as well. And unfortunately, if there is a demise without the patriarch or the matriarch leaving behind a properly drafted will.
Well, Bhavina, what really happens is that if someone doesn't create a will and the person dies, there can be a whole lot of issues. So first thing is that assets will be distributed as per the succession laws. And we know that these laws are very, very complicated, and different regions have different laws. So second thing is that you work so hard to create certain assets over your lifetime. And what everyone wants is that to have some control on how these assets should be dealt with after the death of the person. So you lose control on that. Third is that can be very, very cumbersome for the family to go through this entire legal process, spend a lot of money, spend a lot of time. And I think sometimes we all are guilty of being lazy and not giving due importance to creating a will. So it's very important for everyone to understand that if you don't do it, the family members after the death will have a really tough time. So it's really important that we create a will at a time when we are of sound mind, we are no pressure, no panic, and create in the right manner and make sure that there is equitable distribution to all the people you love, and make sure that there are no infightings after you're gone.
Mr. Rustagi, actually, I forgot to bring on board another very important point to get that clarified, and it's another notion that a lot of individuals have. For example, I'm maybe in my 30s, and I think to myself that it's too early, for me to sort of create a will. I mean, firstly, maybe I don't have that much assets, but yeah, there's really no need for me to create a will now, and that's really the forte, or rather it's really for those people who are maybe already retired or nearing retirement to do. How would you like to bust that myth?
We started by discussing, why it is important to create a will in these challenging times. Like I mentioned earlier, I think there's a constant threat to our health, life. We are in a pandemic situation, and even otherwise, even if the pandemic is not there, the life can be very uncertain, very challenging. So I think it's very wrong to think that one should prepare a will when one is young. I think it's very, very important to list out, like I said, whatever you have created in terms of assets as to how you would like these to be dealt with when the person is not there. So I don't think it's the right way to think that you create a will only when you retire or you have lots of assets. I think it should be done as early as possible. And of course, there will be always opportunities for you to kind of keep, updating that or get a new will. But it's important to start the process as early as possible.
Okay. Yes, start as early as possible, but of course, don't forget to keep updating the will as well. As in when, of course, your wealth increases, the number of assets either increase or decrease. You should always ensure that you update your will. And finally, Mr. Rustagi, one more question on execution of the will. Is it also better that, if let's say I'm not taking any legal help, I'm not, probating the will or anything, is it also better that I mention down who will ensure the proper execution of this will?
Yes, of course, that also is important. But generally, typically, what happens is that the legal heir that you list out in the will, and if that has to come into effect, you would require a probate. Which, for example, if there is an investment and the legal heir want to take that money out, you would require a probate for the will to come into effect.
Okay, well, there you have it, all about estate planning and will planning, and more importantly, busting some of the myths. Myth number 1, estate planning is only for HNIs. Myth number 2, estate planning is for, when you reach maybe the second innings or the later part of your life. So these are some of the 2 most important myths. And yes, myth number 3, that you have to make a trip, to your lawyer's office to draft down a will. These are some of the myths that are busted. Remember, it's never too late. Make sure though that when you start off younger, you keep updating your will to reflect your current assets. That's extremely important, and estate planning is crucial for all, especially if you're the head of the family, if your family is dependent on you. It's important that you need to ensure that you properly make a will as to which assets are being bequeathed to which of your heirs or your family members. Always very important to do that. Okay, well, there you have it. All you need to know. For now, we will take on board some questions and queries from our viewers then. In fact, on this very topic of, will creation and estate planning, we've got actually quite a few questions and queries. So let's get straight to that. Our very first query has come in from Ashish Navlakha. He says, my father has purchased some land around the city and has his name on it. He has passed away though, and he has the following members alive in his family. His own parents, so the grandparents, Ashish's grandparents, his father and mother. He's got a wife and he has 3 children. Basically, Ashish and 2 more of his siblings. So now he wants to know who are the legal heirs and how can they get the land transferred in the legal heir's name. So yes, many a times, unfortunately, in the older generation, many did not understand the importance of will planning, and that's the reason why now that they've left behind all this real estate, it's left for the heirs to decide, how essentially it gets split. So is there some default way or manner in which the property that, the deceased has left behind gets split, Mr. Rustagi?
Well, Movina, since it's mentioned about 712, the document, basically, let me explain that what it is. It's basically an extract of the land record from any district in Maharashtra. So typically in this case, what happens is there are 2 classes of legal heir, class 1 and class 2. Out of the name which have been mentioned there, the mother and the wife and the 3 children will be the class 1 heir. So they will be the legal heir. The father will be class 2. So father will not be a part of this. And so that's one, as to who the legal heir are going to be. The second is that there is a process involved here. So for this, they will have to go to the Tahsildar of the district with all the details in the documents. And once they are all verified, then it goes to basically Patwari, who will actually verify the records and then create the record for them. And that's how their name will get included in that 712. So this is the process that they need to follow to get their name registered.
Okay. Yes. So for all those individuals as well, 712 documents and the significance just explained, by Mr. Rustagi. Okay, let's take on board our next query. Again, somewhat similar. Kumar says, my father has passed away without leaving a will behind. He had some mutual funds in his name with a nominee as his brother. But what is the process of transferring the mutual funds to my father's legal heir? I think what he means to say is that he wants the property to be passed on to him, maybe his siblings as well, and maybe they can split it off. But here in this case, the nominee is very clearly brother, and I guess this could be applicable to maybe bank fixed deposits, your demat accounts, so on and so forth, where it's preferable that individuals write the nominee, write who the nominee should be. A nominee, of course, is if you pass away, then the asset or the financial asset essentially goes on to that person. So then in that case, what would how would essentially they go about, Mr. Rustagi?
In this case, since he specifically mentioned about the mutual funds, so let's understand one thing, that if there is a nominee, the nominee at best is a caretaker. So if there is someone else who is a legal heir, ultimately the asset has to pass on to those beneficiaries. In this case, two things can happen. Okay, if the nominee has already taken out the money, has already claimed the money, typically what happens is that the nominee claims, the mutual fund asks you to sign an indemnity, which clearly indicates that in case there is someone who stakes a claim, then the mutual fund can go to the court and get this money back and pass it on to the rightful holder. That's the one situation. The second is that if the money is still there with the mutual fund and the nominee has not claimed that money, so in that case, the legal heir will have to go to the court, and through the court, they can approach the mutual fund and ensure that the money does not get paid to the nominee. And once all the legal formalities are completed or a succession certificate is obtained, they can then go back to the mutual fund and claim this money. So this is the process they need to follow. But again, the process will vary depending on the situation, whether the money has already been claimed by the nominee or the money has still remained with the mutual fund.
All right, so there you have it. That's, of course, the word coming in. I think it's a very similar question, the next one that we have received from Nayan Gandhi. He says, what's the difference between will and nominee, and in how much time will be taken to transfer the property in consideration? Okay, I think here he's talking about he's talking about a physical property. Just for the benefit of Nayan and maybe for all our other viewers, if you could just reiterate this difference between will and nominee, Mr. Rustagi.
Well, like I mentioned, the nominee is a caretaker, and ultimate beneficiary of the assets is basically those beneficiaries which are listed out in the will. So in this case, we're assuming that there's a will in place. So now there can be a situation where the nominee and the beneficiary in the will can be the same person. The issue is only when there are two different individuals. So like I mentioned earlier, the nominee is a caretaker, and the reason why you put nominee's name is that you don't want the legal process to start for the money that you have invested. So you nominate someone. That person is, like I said, is a caretaker, and if there are some other beneficiaries in the will, they will eventually own these assets. So the nominee is legally bound to pass on the asset to the beneficiaries who are named in the will. So this is basically the difference between a nomination and a will. Like I mentioned again, it's important to understand that at times the nominee and the beneficiary in the will can be the same. So there is no issue in that case. So what happens is that if there is a will, you need to get the probate. Once you get the probate, the will comes into effect, and then you can apply for the transfer of the property in your name. And of course, we know that these processes will take some time, but this is the procedure that one has to follow to get the property transferred in the name of the beneficiary in the will.
Okay. All right, so there you have it. That's basically how will and nominee distinguish themselves from each other. We've just received one more email query, Mr. Rustagi. This has come in from Vimal Kumar Sharma, and he asks how to proceed for the probation of will for execution. I guess a lawyer would definitely be able to help him better with respect to the nitty-gritties of this. But yeah, Mr. Rustagi, if you could just guide Mr. Sharma on this query.
Well, I can like we mentioned again. If there is a will in place, there are beneficiaries there. You need to get a probate. You need to take help of a lawyer to do that. That's obviously not going to be possible to do it on your own. When you approach a lawyer, basically the lawyer will explain to you what is the procedure. But it can be a little lengthy at times, but it's not very complicated.
Okay, well, Mr. Rustagi, thank you so much for joining us today on the Money Show and explaining this entire process of will planning, why it assumes so much importance, and just helping out all of the viewer questions and queries that we've received. If we've not been able to take your query, don't fret. We'll be back next week with a brand new episode of the Money Show tomorrow as well. But we've got something else very special planned on the Money Show tomorrow. For now, we'll do one thing. We will take a very short break right here on the show. Don't go anywhere.